Good evening, everybody. Before we get started, I'd like to ask Bramlett. David, are we on?
He's not even connected.
Yep. Pete, good evening. Have your attention. Before we get started, I'd like to welcome Bramlett to lead us in the invocation.
Good evening. Let's pray together. Our God in heaven, today's International Friendship Day, and so we want to pause and consider something that we don't often think about when it comes to our relationship with you, and that you often present yourself to us as a friend. We come to you in times of need, but often in between we forget that you delight in our company, and that you delight in a relationship with you, and that you want us to delight in you. We confess that so often the busyness, the tyranny of the urgent, the preoccupation with the tangible and the material, fast-paced world around us distracts us from doing that. Please forgive us and stir in our hearts a fresh desire to seek your face, just for the sheer pleasure of being in your company. And Father, we seek your presence for the meeting tonight. We pray that the same qualities that mark a friendship, peace and harmony, will reign in our meeting, in our hearts tonight. We pray for our elected officials and our city staff that are gathered here tonight. We pray for our city tonight. We watch over tonight in our fire stations and police vehicles do so in safety. May all our neighborhoods be under your protection and your grace, and may peace and harmony and friendship reign there as well. And we pray these things in your name. Amen.
Amen. Thank you very much for coming. I'd like to call the regular meeting of the Milton City Council for Monday, August 7th, 2017 to order. So if you'll please call roll and make your announcements.
Good evening, Mayor Council. On behalf of the August 7th, 2017 regular meeting, I would like to remind those in attendance to please silence all cell phones at this time. Those attending the meeting who would like to provide public comment, either during the public hearing or during the call for public comment, you are required to complete a public comment card prior to speaking on the item. There is no public comment for consent agenda items or items under first presentation. Those called to speak will be taken in the order that the speaker cards are received by the city clerk prior to the beginning of tonight's meeting. All speakers will identify themselves by name, address, and organization if applicable. The City Council may allow public comment on either an agenda item or general public comment from a representative of such an organized group or association, provided the individual has filed a notarized affidavit with the city clerk that they have the authority to speak on behalf of that organization prior to the agenda item being called. Demonstration of any sort within the chamber is prohibited, so please refrain from any applause, cheering, booing, outbursts, or dialogue with any person speaking. Anyone in violation will be asked to leave. As I call roll this evening, please confirm your attendance. Mayor Joe Lockwood.
Here.
Councilmember Karen Thurman.
Here.
Councilmember Matt Kuntz.
Here.
Councilmember Bill Luss.
Here.
Councilmember Bert Hewitt.
Here.
Councilmember Joe Longoria.
Here.
And for the record, Councilmember Rick Morick is absent. Would everyone please rise?
Steve, for the record, I think Councilmember Morgan's on his way. Should be here any minute.
Would everyone please rise for the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Good evening, everybody. Glad you're here tonight. Sudi, if you'll please call our first item.
Our first item is approval of the meeting agenda. Agenda item number 17, 200.
I think we want to add an item, and Steve, you have some wording on the agreement, a contract for. purchase of park
I
property?
can. Mr. Mayor, members of the council, we need to add the joint property acquisition agreement with the City of Milton and Alpharetta for park property. We'll explain that when it comes upon the agenda, but I do need a motion and second to add that on the new business agenda this evening.
Okay.
So moved.
Do I have a second?
Second.
Okay, I have a motion from Councilmember Thurman, second from Councilmember Lusk. All in favor to add this item, please say aye.
Aye.
That's unanimous. Okay. Then we'll need to do for the agenda, approval of the agenda. Do I have a motion?
Motion to approve the agenda as modified.
Second.
Okay. I have a motion from Councilmember Hewitt, second from Councilmember Kunitz for the agenda with the modification. All in favor, please say aye.
Aye.
Any opposed? That's unanimous. Okay, next item is public comment. Do we have any general public comment?
We do not have any general public
Okay.
comment.
All right, then we'll move on to the consent agenda. Sudie, if you'll please read those items.
Item, approval of the July 24th, 2017 regular city council meeting minutes, agenda item number 17, 201. The next item is approval of administrative modification 2017-01, northeast corner of Bethany Bend and Cogburn Road, containing 9.09 acres, located in land lot 832 of the 2nd District, 2nd Section, by Arrowhead Real Estate Partners, LLC, to modify Condition 3N, 3R, to revise the grading plan received by the Community Development Department on July 21st, 2017. This is agenda item number 17202. Our third and final consent agenda item, approval of a construction services agreement between the City of Milton and Superior Fence of Georgia, LLC, for the fence construction at Birmingham Falls Elementary and Cogburn Woods Elementary Schools. Agenda item number 17203.
Mayor, I'll move to approve the consent agenda as prepared by staff.
Second.
Okay, I have a motion. Councilmember Lusk, second from Councilmember for approval. All in favor, please say aye.
Aye.
Any opposed? That's unanimous. Okay. Sudie, if we could move on to reports and presentations, if you'll call the first item.
Our first presentation this evening is the swearing in of our new firefighter, Chief Bob Edgar.
Evening, Mayor, Council. First, I want to thank you for the opportunity of doing this and introducing our newest member to our fire department. Brian Cohen is our newest member. He started today. He comes to us, he grew up in Columbus, Georgia. And Brian, why don't you come on up here? Brian grew up in Columbus, Georgia, and he worked for the Dawson County Fire Department for 2 years. Brian moved out of state and worked as a firefighter paramedic for Watertown, Massachusetts Fire Department for 2 years. And he also worked in the emergency room at the Boston Medical Center. Brian has a bachelor's degree in economics from the University of Georgia and is a nationally registered paramedic. And I'd like to introduce to you Brian Cohen.
Hello.
Mayor, if it's all right, if you want to do the oath, or I can do it, it's up to you, sir. All right. I hope you have an opportunity to practice. But I allow the mayor to issue the oath of office.
Nice to meet you.
Glad to have you here.
Thank you very much.
If you'll raise your right hand and repeat after me. I solemnly swear
I solemnly swear
that I am qualified to hold the position of firefighter to which I'm appointed,
that I'm qualified to hold the position of firefighter to which I'm appointed,
and for so long as I am employed with the City of Milton,
and for so long as I am employed by the City of Milton,
I do solemnly swear and affirm that I will support
I do solemnly swear and affirm that I will support
and defend the Constitution of the United States of America
and defend the Constitution of the United States of America
and of the Constitution of the State of Georgia,
and the Constitution of the State of Georgia,
and I will faithfully perform
and I will faithfully perform
and discharge the duties of my position,
and discharge the
duties of my position,
duties of my position,
conscientiously and without malice
conscientiously and without malice
or partiality to the best of my ability.
or partiality to the best of my ability.
I further swear and affirm
I further swear and affirm
to obey,
to obey,
to adhere to uphold and enforce the laws of the United States of America,
to uphold and enforce the laws of the United States of America,
the state of Georgia,
the state of Georgia,
and the city of Milton at all times.
and the city of Milton at all times.
I further swear and affirm
I further swear and affirm
that I will bear the true faith
that I will bear the true faith
and allegiance to the city of Milton
and allegiance to the city of Milton
and the officers appointed over me
and the officers appointed over me
according to the law,
according to the law.
so help me God.
So help me God.
Congratulations.
Thank you very much. Appreciate it.
Yeah, I think we would sign that.
Should I let my wife out?
Yeah, absolutely. You want us back here?
Yes, would you mind?
Yeah.
Yeah, no, absolutely.
She understands.
I do. I really do.
Everybody will take a half step this way, shifting towards the next space. More perfect. Looking right here. One, one. Flash. One, one, two. Still one more. One, two. Double check. Good. Thank you.
Again, I never want to miss an opportunity to thank our public safety. Brian, thank you for your commitment to our city. All of you in the audience, just keep in mind that all these guys here that are in uniform wake up every day and put us, the citizens, first and are willing to risk their life and health to keep us safe. So thank you, guys. All right, City, if you'll please call the next presentation.
Our next presentation is a proclamation recognizing Ms. Kathy Johnson's service to the city of Milton. This is being presented by Mayor Joe Lockwood.
Okay, I'm proud tonight to present this proclamation for Kathy. And this is recognizing Kathleen Johnson for her service to Milton. Whereas Kathleen Johnson has been active in the environmental and conservation arenas for more than 20 years. She must have started when you were 2. And whereas Kathleen has lived in Milton for 9 years and has been involved in local conservation and environmental issues as a volunteer, and whereas she worked extensively as a member of Milton Grows Green, and whereas she gave unselfishly of her time and talents with Milton's young people both through MGG outreach and as a parent volunteer at our area schools, ensuring a new generation of responsible land stewards. And whereas Kathleen joined the Milton staff on February 1st, 2016 as Conservation Project Manager, and whereas she played a pivotal role in the city's green space bond process, Milton's first major effort to save our precious remaining undeveloped land, and whereas she's worked directly with Milton citizens to take their words and green space needs and turn them into the bond language and criteria that will guide the city in deciding which land will be acquired with the bond process or bond proceeds, and whereas her efforts will lead to the preservation of land in our community that will be used and enjoyed by present and future citizens in perpetuity as parks, trails, and natural areas. Now, therefore, we, the mayor and the city council of the city of Milton, hereby recognize and thank Kathleen Johnson for her dedicated service to the city, and its citizens, and this is given under my hand and seal of the City of Milton, Georgia, on the 7th day of August, 2017. And Kathleen, if you and your family would step forward, and the council, glad to present this proclamation.
Give a half step, everybody this way. Tighten up for me. One right here. One, two, three. Let's do it again. One, two, three. Good, thank you.
And again, just like our public safety, our, I know Kathy filled an important position with the city, but also all your volunteer work, and that goes to everyone else that's volunteered. I always say that's what makes our city so great is all the folks that live here and care and volunteer their time and efforts, and it makes a huge difference. So thank you very much. We don't have any items under our first presentation, public hearing, or the zoning agenda, so we'll move to unfinished business. Sudi, if you'll please call the first item.
First item is consideration of an ordinance to amend Chapter 20 of the City Code, Noise Control. Agenda item number 17170. First presentation was at the July 10th regular City Council meeting. I do have 3 public comments. Do we want to hold on those or go now?
What's that? I'm sorry.
I have 3 public comments. Do you want to hear those now? Or?
Yes, I would like to hear. Or if the council's okay with that, I'd like to hear public comment first. Okay, if you'll please call the first person.
First speaker is Jose Kramer.
I feel like I'm on the deck of the USS Enterprise over here.
Just don't grab the steering wheel.
Yeah. Good evening. My name is Joe Kramer. I live at 125 Winstead Court in the city of Milton. And first of all, I'd like to thank the mayor, city council members, and the entire city of Milton staff for bringing to life this beautiful building and community center. You're all to be congratulated for your hard work and dedication in making this city hall become a reality, and we all appreciate it. Today, I come before you to talk about a topic I presented to you several years ago, at least 4 out of 7 of you, and that's noise. More specifically, I want to talk about the noise coming from the Milton High School Stadium. Despite continuous efforts over time with several school administrations, the noise problem at the school is at its worst. Prior to construction of the school, our neighborhood was told by a Board of Education representative that noise would not be a big problem because there were only 5 football home games a year. What they did not say was that while there were only 5 varsity home games per year, there were also freshman, junior varsity, and feeder football teams using the sound at the stadium on Thursday, Friday nights, and all day Saturday. Over the past couple of years, the other sports teams at the high school have decided they too need to blast music from the loudspeaker system and have their announcers scream into the microphone each play-by-play. During the spring, the sound system is cranked up nearly every night and on the weekends. The music starts an hour before game time, is played for every break in the action, and continues long past the time the last fan has left the stadium. And while I'm no prude, the music choices played on the sound system contain some of the filthiest lyrics I've ever heard in my life. And it's broadcast all over the surrounding area, night after night. Which brings me to the latest edition of the sound ordinance. The changes seem mostly geared towards residential and commercial regulation of noise. As far as noise coming from the school is concerned, the revised ordinance either exempts schools, including private schools, or is silent where amplified sound is concerned. We have been told in the past that the city cannot regulate what the Fulton County School does, but certainly it should take the position that the citizens of Milton are owed the courtesy of respect for the city ordinances, even if that means compliance is voluntary. I urge the City Council to develop a plan to address the problem of noise coming from the schools in order to live up to the stated objective of the original sound ordinance of preserving the quality of life of the citizens of Milton. Thank you for your time.
Thank you, sir. Judy, if you'd please call the next speaker.
Our next speaker is Richard Armenti.
Good evening. I'm Richard Armenti at 1450 Birmingham Road. And I have similar comments as well that the new ordinance is incredible. Thank you so much for the work that's gone into it. I've read it, and it's truly a lot of work, time, and hours that went into it. It's very similar to Roswell and Alpharetta. The one thing that when I looked up in Alpharetta and Roswell, they all have similarities. And one thing that concerns me is that I have a property that's directly behind me, and I'm on a hill, so there's 25 homes. Now, I'm not a contractor, even though I claim that I built my house. It takes about 15 subcontractors to build a home. So that's 375 contractors over the course of 5 years to develop that community. So if it's just a noise ordinance, technically they can be there 24 hours a day, 365 days a year. Now, maybe I missed it. Maybe it was built into a construction ordinance where they can't be on the property, but it is overwhelming. My neighbor Brian Bush is here as well to corroborate that what these workers are doing is they're coming on every holiday you can think of, picking up gear, things like this, something where you just can't have video every single time of it happening. So I didn't know if there's a way to build into that noise ordinance something where just work within the hours that you've given them. I think it's like 70 hours a week where they can be on the property. So if they could eliminate, from being there from 7 at night till, 6 in the morning, that would be great. It would truly cut down on the massive amount of traffic that would come through that particular subdivision. That's all I had. Thank you.
Okay, thank you. Judy, if you'd please call the next speaker.
Our final speaker this evening is Theodore Cox.
Good evening, Mayor, City Council members. Theodore Cox, 13860 Bethany Oaks Point. I'm here tonight to address the noise ordinance, in particular how Milton regulates noise on AG1 property operating with a use permit. As you know by the document presented for your approval tonight, commercial property is now defined to include any and all properties operating with a use permit. I believe this may be an overly broad definition and look forward to additional clarification, which I discussed earlier today with Robin McDonald. I've been before the City Council several times regarding the festival event use permit granted at 13895 Hopewell Road, which is AG1 property adjacent to the Bethany Oaks subdivision. As discussed in 2015, the noise ordinance applied to this use permit was essentially identical to the noise ordinance applied to commercial establishments. In 2015, the City Council heard how the level of music coming from a bar like Montana's was the standard that applied to this AG1 property. In particular, the required standard for festivals or events, outdoor, indoor, has a maximum continuous sound of 60 decibels, that's dBA, and a maximum peak of 75. In the case of the property in question, the noise could be 75 decibels at dBA until 10 p.m. at night, 365 days a year. Yet the newly proposed commercial noise ordinance restricts noise to 60 decibels after 9 p.m. Thursday to Sunday. So yes, a louder and later limitation for this use permit property would exist than is permitted by your own newly proposed commercial standard. And keep in mind that the use permit I am discussing is for a property that is roughly 2 acres from the Bethany Oaks subdivision. It's not on an 80-acre property such as Little River Venue. Compliance with the required standard for festivals or events is the standard that is applied to the property in question. Hence, if the noise standard is raised for festivals, as it's now being increased for commercial activities to 85 decibels, would this also apply to all existing use permits by festival events? It seems very unclear by my review of the ordinance. Also, to put noise levels in context, a passenger car at 65 miles per hour at a distance of 25 feet is 77 decibels. A vacuum cleaner is 70 decibels. Note that 80 decibels is twice as loud as 70, as it's a logarithmic scale. A diesel truck at 40 miles per hour at 50 feet is 84 decibels. A diesel train at 45 miles per hour at 100 feet is 83 decibels. This type of noise seems very high for a use permit on AG1 property, if any such properties exist that are not otherwise subject to a specific noise limitation. Also, I understand the proposed ordinance was patterned after Charlotte-Mecklenburg, but clearly Milton is not Charlotte. Hence, I question, does a use permit in Milton, a horse community, have an entirely different definition than a use permit in Charlotte? I suspect it does. In this regard, I would bring the noise ordinance of Johns Creek to your attention. In July 2016, Johns Creek passed a nuisance law based on a quote-unquote plainly audible standard to determine whether amplified sound from an entertainment venue is violating the noise ordinance. According to this plainly audible standard, a violation occurs when a listener with normal hearing can understand speech, whether the voice is normal or raised, and whether the listener can distinguish repetitive bass sounds and musical rhythms without the aid of a listening device. Furthermore, Johns Creek specifically defined a noise nuisance as any artificial noise exceeding 55 decibels from 7 a.m. to 11 p.m. The actual language states that no property owner shall employ any device or instrument at an entertainment venue that creates or amplifies sound that is plainly audible at a receiving residential property, including loudspeakers, amplifiers, and public address systems. I stress again, their limitation is 55 decibels, reducing to 40 decibels after 11 p.m., not 60 decibels, as I'm subject to, nor certainly not 75 peak decibels. If you don't mind, I will quote what Johns Creek's Mayor Mike Bodker said in the newspaper. The new noise provision of the nuisance ordinance balances the desire by residents to be able to quietly and peacefully enjoy their homes without undue disruption of their daily lives. Our community wants our businesses to successfully operate while limiting noise emanating from the inside of their businesses. I cannot agree more. Thank you very much.
Thank you. Is that all public comment?
That's all, sir.
We'll, I think Kathleen.
Yes. Good evening, Mr. Mayor, members of the council. As you know, we recently discussed the draft of this ordinance, and at that time you did ask us to make some modifications to it, and those have been duly made. And Robin and our student intern, Taylor, are both here to give you that presentation. Thank you very much.
Sorry, I had this set up before. Okay, I'll just go ahead and start. So as Kathy said, we took the comments and input that you all provided to us at the work session regarding this item back in July, I believe. So I'll just go ahead. I won't reiterate what was discussed before, but I'm going to just highlight what are the things that we changed based on those discussions, as well as there might be one or two things that we've gotten input from since that time from other people. The first one is a general noise. Section 20-657, prohibited when creating quote-unquote loud and unreasonable noise with no minimum sound. And what we did was we tweaked the actual wording, as well as we included a definition. And grateful to the police department that did a little bit of research for us in this area. They found several jurisdictions that had this type of provision. And their definitions that we also considered and used parts of was loud and unreasonable noise means any sound or noise, including but not limited to music or speech, which is so loud in volume level and of such duration or character as to disturb the comfort, health, peace, safety, quiet enjoyment, or repose of one or more persons of ordinary sensibilities. So I know there was some discussions about doing a minimum DBA for something that was more objective. We reviewed this with the city attorney, and he felt comfortable with this definition. I think Lieutenant Barstow had given an example of, a situation where you're in an apartment and there's somebody above you that keeps on moving furniture, and they're like, just making tons of noise, but it would never meet the DBA minimum amount, but it would be disturbing you over a matter of time and days. And so that was like an example of, okay, it may not meet a DBA, but it certainly is a noise and unreasonable noise that happens. So that's the explanation and what we were proposing for that section. As we go on to section 20-659, sounds impacting residential life, and mainly we're addressing, I'm sorry, I gave you a revision that's on your dais that has August 7th on the bottom left, so you'll know that that's the correct one. This is where I added a couple of additions since the publishing on Thursday. And it was just addressing some issues that was brought up at the work session. And those are clarified allowance of garage and construction activity for individuals, and also changed, so that's the part that's in the highlighted yellow that was not in the packet on Thursday that was published afternoon. And then what was changed in red was some of the timing. So there was a great suggestion, I believe, by a community or a citizen that suggested it be sunset. And that kind of changes with the seasons, as well as there's an official sunset time that's given each day. And so those are the changes that were made to that table. And I added on the second column, operation of construction machinery by individuals on their residential property which registers more than 70 dBA at the nearest complainant's property line. So being that you could pretty much operate your machinery, except when it goes over 70 dBA, then it would be for those times. And the same for the garage machinery, a few columns to the right. Let's go on to general exemptions. It's right below the table under 3. It states reasonable activities conducted on public playgrounds and public or private school grounds, which are conducted in accordance with the manner in which such spaces are generally used, including but not limited to school athletic and school entertainment events up to 12 midnight. So that is the exemption that we added, which was a request of the City Council. And as we go further down into the chart, we'll go to the last addition that was made was suggested by the police department, and that is on page 9. And it allows for mediation for ongoing unresolved situations between parties with the Fulton County Alternative Dispute Resolution of Fulton County Superior Court. So this is an entity that if there's just, many times staff, we deal with issues between two property owners, not necessarily sound, and we're kind of like, okay, it's between the two of you, and it'll come up again and again. So this actually is a great reminder that service is available. But specifically for noise issues, this can be a way to help resolve it. So it's not really the city doing it, but we're just proposing that that's a way that they can resolve between two parties some noise issues. And with that, I'm here to answer any questions and any input you may have.
Questions, Karen?
We had 3 residents come and speak, and they had some specific issues. Can you address any of their issues?
So the last one with Mr. Runner's property on Hopewell and the issue of the use permit, and I can directly address that it is the use permit that was approved, or any use permit, if it has any type of sound requirements of the use permit and or even more restrictive requirements for conditions of the use permit, that would supersede any other of the noise requirements. So, and that's stated in the use permit section, that if it's more restrictive, it would supersede the ordinances. So.
And on that property, what were the conditions of the use permit?
It was as the gentleman stated, we just talked today. I didn't bring the actual use permit, but it was whatever he said, and I think he had it written down. It was either 60 or 65 generally, and then wait a minute, it's in the use permit section. I'm sorry. It was the timing that changed that was different. So in Mr. Runner's property, it said that all artificial sound shall cease at 10 p.m. And then also that all artificial sounds shall be emitted from the western section on the side of the Hopewell side of the house. And then the use permit for that particular use permit. Now, he was under the old one, not the new one that Little River Farms is under. And I should have had it marked. Okay, here it is. It was the very first one. A maximum continuous sound level of 60 dBA and a maximum peak sound level of 75 dBA shall not be exceeded at property lines of adjacent residential districts or AG1 districts used for single-family dwellings. So that's what, if that operation was operating, that's what they would be required to do, as well as ceasing any artificial sound at 10 p.m.
Okay. So. Karen, you have any more?
Well, I didn't know about the other ones. I know we have one with the school, and then also as far as construction equipment.
I can't speak to the school specifically about their complaints, and then
the construction equipment.
The construction. So typically, the ordinance is dealing with construction noise, and I mean, we haven't. If there are issues that they are making noise, like on Sundays and holidays, that's not permitted, so we need to know about that. So that's just in general of enforcement. But I guess technically, if you're inside your house, or if there's a contractor that's inside a house and they're not emitting noise, there's nothing to keep them from, doing their work if they're not emitting noise. That's a true statement. I'm not sure if that's very typical, that you have contractors going out 24/7 going to houses. So, and if there are issues with that, I mean, if they're making noise.
If they're making noise, then they have to adhere to the noise ordinance.
Correct.
I guess if we want to restrict their work, it would be in a whole different ordinance.
Correct. It would be a different ordinance. And then we can look at that when we look at the UDC, if that's something that you would like us to look at.
And I'd want to add too, just on the school and the noise and the loudspeakers. I wonder if maybe ask staff to reach out to the local school and just see if they can monitor that a little bit too. Some of the things I've heard before too aren't really PG. So some of the music, I don't know if we can limit any of that or not, but some common sense there would be nice.
Okay.
I think Joe, you had.
Yeah. So, well, following on to the question about the school, I mean, for some reason in the back of my head, Robin, I've got the idea that as property owners in the city of Milton, the Fulton County Board of Education is somehow exempt from following certain laws and ordinances for the city. Is that a true statement, or am I confused?
You take a shot at that, Councilman Longoria. The answer is you're not confused. The answer is generally that is in fact the case. What the law provides is that a jurisdiction like a Board of Education or a county government or any entity that has the condemnation power is generally exempt from local zoning ordinances. And you may think, well, what's the definition of a zoning ordinance? It's any ordinance exercise of the police power that divides up a jurisdiction into different districts and then imposes different rules based upon that division. You'll notice that the noise ordinance talks about uses that can occur in commercial areas, talks about uses that can occur in residential areas, makes specific cross-reference back to our various specific zoning designations. And so therefore, I think the Board of Education would have a fairly compelling argument to make that they are in fact exempt from our noise ordinance. And of course, it may stand to reason. The whole reason of these exemptions is the notion that entities that have condemnation power are the sole arbiter of what property is best to put various uses on. And if a local zoning ordinance could trump that, then we would de facto be able to tell the school system where they can put their facilities. And so we've had this same issue come up in the context of the sign ordinance as well, with the school system taking the position that they can put monument signs with a fairly bright, changeable copy where they wanted to in derogation of our sign code. So, I will say this, though. I have worked in governments before that have had a lot of success calling up these other jurisdictions and basically saying, while you may be able to do this, maybe that's not the best thing to do, even though you may have a legal entitlement to do it. I would also say, though, that even some of the language that we've talked about adding on page 3 of this ordinance, the exemptions that Robin was talking about under C3, is everybody following me there? The red language under C3 on page 3? That sort of addresses, even if we were to assume that the school system was in fact required to comply, I think that language, activities conducted on, let me just read it the way I would read it if I was their attorney, activities conducted on public school grounds which are conducted in accordance with the manner in which such spaces are generally used, including school athletic and entertainment events up to 12 p.m. midnight. Well, I think right there we've sort of established that some of those uses that I think some folks in here just were concerned about would have been appropriate up until midnight. At least that's the way I read that.
So to get to one of our citizens, questions is, when the school was going in, and I would agree, you can't argue about where the school board wants to put a school, all right?
Fair enough, yes.
But the school's in the ground. The school's already there. So it would seem like we ought to have some kind of recourse, some kind of relief when the operation of the school or what we expected in terms of the operation of the school doesn't necessarily line up with maybe what we were told on the front end.
That's right. And again, I don't want to speak for the city manager or staff. I don't know if there has been any formal communication to the school system, both about the content of the music. I certainly understand that. I live near I know what that's like.
Yeah.
But then also the volume. And even I think there was actually 3, the volume, the content, and actually the length of time, even after the crowds have long gone.
Right. Okay. I had a couple other questions real quick. So, Robin, when we talked about this at the work session, there were a couple of issues that I was worried about. And the biggest one of these is establishing objective criteria for use in the ordinance versus subjective criteria. And you gave us a good example of that in terms of the language change that you guys were thinking about. And here's the worry that I have. If we get a noise call from a citizen who says the noise is unreasonable, it's unreasonable to them, and we show up, an officer thinks that the noise is not unreasonable, we are pitting our city employees against our citizens with no clear way of determining who's right. Now, a decibel is something that can be measured. A decibel is something that you can establish very easily. And so if our ordinance says 55 decibels is the limit, and somebody calls up and complains, the officer shows up, holds up a decibel meter, and can show, oh, look, it's only at 45, at least we don't have the debate that would ensue. So how are we going to address that?
I'll jump in on there. So reasonableness is a standard that is used ubiquitously throughout criminal law, and it's based off the standard of what a reasonable man would believe. You'll find that in situations with uses of force, noise is another example, anywhere where you wouldn't necessarily have a quantitative measure to be able to make a determination. I wanted to go in the direction, I feel more comfortable saying, okay, if you hit a certain decibel, that's it. Just like you said, here it is, ma'am. Here, either you violated it or you didn't. However, in the world of different types of annoyances and noises that can be created, it's very difficult to be able to create an objective measure for everything that actually may be a nuisance to a reasonable man. And there comes in that reasonableness perspective. And that's why we end up having judges and courts and all that. The officer uses his or her best ability to determine what a reasonable man would believe, and they apply that measure. And yes, it does put police officers in a lot of sticky situations where people get very angry and feel that the police are not doing their job. Conversely, sometimes when they take the other route, people feel that they did more than they should have done. But it is a situation that's common to law enforcement.
Candidly, Councilmember Longoria, that standard, the reasonable person standard, attorneys love it, of course, because there's always going to be two sides to fight about, right? What is the reasonable standard? And it does, to the city manager's point, put the code enforcement officer somewhat in the role of having to immediately make a judgment call as whether a citation should issue. They may, in fact, but again, that's a function also of training and also knowing the proclivities of the city court, which that'll be prosecuted in, whether or not they think a case would actually, survive if there was in fact an enforcement action taken. But really, this language though is just a recognition of the fact that the decibel, the objective approach, doesn't always capture what can otherwise be offensive to someone of reasonable or ordinary sensibilities. If it is in fact we always have to meet the bar of a certain number of decibels at the property line, then we may in fact have to walk away from some clearly, objectively offensive and irritating noises that we simply do not have the prosecutorial authority to cite. And so it's sort of a stopgap. It's a way for those difficult situations that simply don't meet the decimal-based system to still capture them. I think that's the purpose of it.
Okay. The last question I have, Robin, is as one of our citizens pointed out, the decibel scale is not your average scale. So as you move up, things are getting larger, louder, however you want to measure it, much quicker than what we're used to. So it's not, 1 to 100, it doesn't increment by 1 each time. 1 to 100, it's incrementing by 2 every 10 steps you take. And so because of that, somebody might think that there's not too much difference between 70 and 75, 60 and 65, 65 and 70, when in reality, it's a big difference. And he did a good job of pointing out, freight train at this distance, that kind of stuff. What kind of changes did we make in the ordinance that would have changed where we have decibel numbers involved, that would have raised or changed the decibels that we were concerned with or considering? Did we have any, or did we leave those, for the most part, the same?
I would have to look at what they're fairly consistent. I mean, there's not a huge difference between the decibel levels. It was just a matter of reorganizing it and being more specific and easier to enforce. So
it's a fair statement to say that we're not changing where we had objective criteria in terms of decibels. We didn't change that criteria. We just made it easier to implement.
I think that I don't want to say that in all cases that's going to exactly be the case. it would be unfair for us, I think, to respond that way right now.
I mean, it's a new ordinance, but it's not like it's radically different as far as
My
the
point
decibel
is,
levels.
what justification did we come up with if we raise the decibel level in any of those measurements? How did we justify that?
And I don't know that we did raise it, and I don't know that we did lower it. So in fairness, if we could, and I apologize, I had the original one sitting in my hand, and I grabbed the contracts instead.
I have a bunch of copies at my desk that I had the last time to give to you. But.
It is the old one. There were general standards at about 60 and 65 and up to 70 dBA, which adjusted with time, duration of time of the noise, and whether it was a residential or commercial neighborhood. I don't want to give you an assurance that none of that has gone up or down without.
I'm okay with it going down. I'm just worried if it goes up, why would we have let it go up? Because I thought even though the current ordinance has some flaws, I thought it was doing a good job.
If it went up, it wouldn't have been something that was done with any intent in mind. So if something did go up, and I'll defer to Ken on this, if we go back and compare the two and something did allow for a higher level of sound, and I don't know if this is doable or not, if you want to pass something tonight, I don't know if we could go back to switch that or not, or if that is too much of a material change.
Yeah, I think that would be challenging to just have that built into your motion that we are then going to do a comparison, simply because that is so critical to the very ordinance you're talking about. So my thought is if you want to adopt something this evening, adopt what is close to presented in front of you, and then if staff goes back and sees that we may have raised some decibel levels where perhaps that's not the intent of the council, we'll need to bring it back to you with an addendum.
All right, thank you.
Rick?
Yeah, Robin, could you, the one question I have regarding operation of construction machinery by commercial users, what did it used to be as far as the hours that we had stated in the old noise ordinance?
It didn't speak to that specific type of use. So, I mean, this was much more specific. It just spoke to noises emitting from a certain property. It didn't talk about different types of noises. So I'm going to bring it up right now. So if that makes sense, you can't compare apples to oranges because there were no apples. So
I guess where I'm going to is I understand as far as an individual on their own property operating construction equipment, and also when we talked about like professional lawn care, you may, if I'm out using my lawnmower, I may want to be able to go to sunset, but I don't think we should have the ability for builders to go from 7:30 a.m. until sunset, because that makes it way past. I thought it was an earlier stop. In the past, I thought it was limited as far as when they could start and when they had to stop.
Right. So the exemptions before, as in the old ordinance, or you mean before I changed it to sunset?
So it was 7:30 to 7:30. They could work 12 hours.
Right.
I guess I'd like to see us change that one, because I do think that's an impact. If we also, when we talked about the sunset, I think that works well if we talk about homeowners or it could be even commercial lawn maintenance people. But when you talk about construction of homes with hammers and jacks and different things like that, I would think we'd want to keep it to the 12-hour thing where it's 7:30 to 7:30. Right.
So I have it up right
unless
now.
Unless it's sunset comes before then. But I don't.
Is there a way to do it such that we have a hard stop time or sunset, whichever is
7:30 p.m. or sunset.
Whichever
is earlier. Yeah. I just think that for me, as we're still building out neighborhoods and doing commercial construction, I think that would be an issue for residents if we're allowing noise to go till sunset, especially during the summer evenings.
I think we ought to put a hard number on it, not an or. So I mean, if it's 7:30 to 7:30, then let's do that.
That's the current.
Well, the only question is when we have shorter hours during are you thinking like when we get into winter months, if there's still construction, they should be able to go after dark?
I don't know if that really matters.
I think that's where.
I mean, I think I don't know. I would just assume it'd be 7:30 to 7:30. 300 or whatever, Monday through Friday.
Well, if we could look at doing a change, I definitely think it should be to sunset, especially during the summer hours. I think a hard rule, and I guess I'll wait to hear other comments whether or not we think we ought to, during the summertime or during the wintertime, have it actually, whichever is earlier. And the same thing, I guess, goes for those same standards for Saturday. We have a later start time, right? At 9 a.m. is when they can start on Saturdays.
Which it was the same as it was. And I just want to, we're talking about commercial construction.
Construction machinery by commercial users.
So just for a point of clarification, how it's currently listed in there is sunset to 7:30 a.m. So whatever sunset would be until 7:30 a.m. the following day, as long as it's not a weekend, it would apply. On Saturdays, it would be sunset to 9 a.m., which I'm going back to our old code. It would have been, if it wasn't a weekend, it was 7:30 p.m. until 9 a.m. the next day. And then, of course, similar to our old one, it applies on Sundays and federal holidays. So right now, sunset is the point of stopping. Correct me if I'm wrong. I'm reading this correctly. Yes. Sunset would be that point. So obviously, it would adjust with the season.
Did it used to be like 9 a.m. to 6 p.m.? Was that the
So
old
that's
Saturday?
for Saturdays.
And
9
otherwise,
a.m.
it was 7:30 a.m. to 7:30 p.m.
on weekdays.
Okay, so I'd ask that we also consider doing that for commercial construction, like where you're building homes or you're building commercial properties. We don't have it 9 a.m. to, I think it's written backwards here, sunset to 9 a.m. I think we meant 9 a.m. to sunset is allowable.
This is when it's prohibited.
Right.
That's prohibited.
So prohibited sunset to 9 a.m.
Correct.
But then what about as far as available use? Then it
would be like 9:01 to sunset. That's when you could do it on a Saturday.
when did we used to have it? What time did it stop on Saturday?
The previous, I don't know if it's on your screen, but it's 9 a.m. to 6 p.m. That's when you could, it's kind of the opposite way, but you could have construction, noise, or activity 9 a.m. to 6 p.m. on Saturdays and none at all on Sundays or federal holidays.
Yeah. I think that's my view. I think we ought to do something like that. If that's the will of the council. I think, again, I'm thinking of if you're a resident and you're on the weekend, you don't want construction going on until 9 p.m. on a Saturday when you're trying to entertain in the evening. I just think we need to look at actually coming up with some more firm times when it comes to commercial construction equipment. So if we could look at that. The other question, as it relates to the schools, are we saying that we can't, by law, we have no jurisdiction when it comes to noise, Ken?
That is what I'm suggesting to you.
Okay, then I guess what I would like to see is, we did this back when we first formed as a city. A bunch of us or a few of us from council did meet with the Board of Ed representative for our areas as well as with the schools. I think we may have had a couple of citizens, but where we had specific examples of issues. In the new ordinance, it says it's exempted, it shall not apply, but we've got the thing in there that says reasonable activities. And I think reasonableness comes into language, loudness, duration, but I think that's something we need to go forward. I'd be willing to be part of that, to actually talk to the schools, but I think we do need to, in this instance, go forward, because with Mr. Kramer living right across from the school, we had this problem 10 years ago when we started, and we got them to temper it down a little bit, but it sounds like we're back to now even worse than where we started.
Councilor Morg, let me just clarify. I don't want to speak too prematurely. My point is that there is a well-established set of case law that suggests that police power exercises, typically in the form of ordinances that divide jurisdictions up into zoning designations or rely on zoning designations, are not enforceable against entities that have the power of condemnation, like the school system. So that's a little more of a nuanced answer. I am not prepared to tell you that there is no exercise of a noise-like regulation that the city of Milton could ever draft. I haven't had a chance to review that. So I would want to put that point of clarification in before I...
Is that something you could actually look to try to get us a little bit more definitive answer?
I could. I could look at that. I haven't been asked to do that, but if that's the will of the council, that they want to know if they have any ability whatsoever to enforce noise protocols on the Fulton County school system, then I will be happy to look at that.
I'd be interested to see, again, if I have support, I'd be interested to have you do that. And also, I think we need open dialogue once again with the Board of Ed. I think Katie Reeves is still our contact point, and then also with the principal or administration of the high school. I think we need to, if this is an issue that people around there are experiencing, I think we need to at least open dialogue and try to see if we can resolve, as well as find out what the legal implications are.
And I would just point out, if we're going to consider doing that, we ought to strike out the language that disclaims schools from the ordinance, because otherwise we're opening it up for them.
Well, that would include language where even if we say it's enforceable, in some variation, they would look at it and say, well, you've given your approval right here.
And I guess that comes back to one of the questions earlier is, can we, when we're making changes as far as the time for commercial, is this something that we're going to have to actually bring back versus say, let's pass something like this if we've got questions?
Well, no. I mean, to the extent that right now we are plugging in modifications to what has been presented to you that we know the answer to, I'm comfortable with that. What I wasn't comfortable with is us approving something but then saying, but staff, go take a look, and if we've deviated from our old ordinance, then any deviation goes back to the old ordinance. I'm not comfortable with that, because anybody viewing this wouldn't know what we just adopted.
Okay. Bill? Then Bert?
As relates to Milton High School, wonder how many times, and if I'm sure it's on the record, where Milton PD has gone out and checked the decibel levels at the school property limits. And I'd be interested in what the actual readings are out there. I know this issue has been going on for the last, 15 years or almost 20 years since Milton High School was opened. And I live over 3 miles away from Milton High School, and I can hear the noise out there, particularly the band. And of course, during football games, I can hear the loudspeaker. I'd really be in favor of getting together with Katie and the superintendent, and let's open this dialogue about how we can resolve this issue. Shoot, half of our property tax out here goes towards the school system. I think we should have some voice in this matter. The other thing that Mr. Kramer brought out was the content of during the games and practices and the other events that go on there. That really concerns me. If there's lewd content coming across loudspeakers during games and practices, is that the same content that they allow within the high school and the other schools in our system, middle schools and the elementary schools? If that's the case, I think we've got a bigger problem. So I think this ought to be part of the discussion with the school board. As it relates to construction hours, go along with Bert's comment and what Rick had to say too. Having been in construction for all my life, I can appreciate the opportunity to work on projects just as long as possible when the weather's cooperative. However, I think there is a limit, particularly in these newer areas or in residential areas. I think we need to go back to the 7:30 to 7:30 restriction. And I would be interested to know, I haven't pulled a permit in a long time, but is that one of the conditions placed on the building permits, restriction of work hours?
Yes, it is. It's on the permit.
Well,
Robin, just to clarify, it's on the permit that they can't make noise beyond
No,
those.
I mean, it gives the construction, the allowable, this section of the exemption of when you're allowed to have construction noises.
Right, I just want to make sure we're on the same page.
Yeah.
This is on the building permit regarding noise that can emanate from the site, not when
Right.
they can be on the site.
Right, correct. That's a noise emanate.
well, not only
coming from it.
building permit, but the grading permit too. And there's
Correct, and all of our, whether it's a grading permit or a building permit, they all have the same statement on it, so yes.
Okay. In as regards using sunset as a later time limit and working, sunrise and sunsets vary every day of the year, and I think it places an additional burden on our public safety, our Milton Police Department, if they're out trying to enforce a noise ordinance, and when that later limit changes every day. I think we need to set a specific limit like we did in the past, 7:30 to 7:30. I think that's ample time to work and to create noise, particularly when it disturbs peaceful use of people's property.
So I think, Ken, and you might know this, I think our friends in Forsyth County have 7 to 7 and 9 to 6 on Saturday, 7 to 7 Monday through Friday and 9 to 6 on Saturday. And I believe, and we may want to look at changing this in our heading in our chart, is it's outdoor construction activities that emit noise. Because there's plenty of stuff that makes noise on a job that's not a piece of construction equipment. So we may want to look at that. And I think in Forsyth County, too, sort of to Bill's point, it's on the cover sheet of each set of plans, the civils and the architecturals. And I think they also post a sign up at the job, too. So that may help some of those, because ignorance isn't an excuse, but a lot of people don't know. So that may be something we want to look at going forward, having that as a requirement on the cover sheet of our plans, and maybe posting something on that on the permit box or something along those lines.
Just want to be clear, we're talking about restricting any work or any work that creates noise.
I would say, I think that in Forsyth County, Ken, and you can correct me, I think
it's work.
It's out exterior activities.
Yep. And we'll have to look at that outside of 20. There's a few things that have come out outside of 20 as we've discussed this, so maybe this is bigger than just the noise ordinance.
Yeah, it's not just a noise issue. It's a development code issue. Right.
Bill?
I'd like to reinforce that, too. It's not only the noise of construction equipment, as Mr. Armenti brought to light here. It's the traffic coming in and out of residential areas. I think that's a nuisance. So.
Karen?
If we're going to change to hard stop times, which I agree with, I really think on weekends, Sundays, and holidays, it needs to be 6 o'clock. It does not need to be 7:30 on Saturdays, Sundays, and holidays. So I think it needs to go back to being 6 o'clock p.m. rather than the 7:30 or sunset for those days.
I think Sundays and holidays are exempt altogether.
For commercial.
And also
Commercial.
clarify, may
Are you
have
speaking
some.
of commercial type?
Well, yeah, I mean, there are different ones. I know they're exempt on for certain stuff, but I mean, for others, I think.
So currently for commercial users, it's the 4th, anyway, it's Saturday. Right now it's sunset to 9 a.m. So you're saying 7:30 or no, 6 p.m. like it was.
Yeah, on Saturday, yes.
To 9 a.m.
They don't need to be working
So 9 a.m. to 6
9 o'clock
p.m.
on a Saturday night. I mean.
Right. And then Sundays and federal holidays, you can't work it. Well, you can't emit sound. That's how it is.
That's what we need to clarify, too, is that any work, I mean, you may have somebody painting inside of a house.
Right.
It's not emitting any noise, but
It doesn't, but that is part of the conversation that's
Right.
been going on here.
Yeah.
So if you want us to go back and look at that outside of the noise ordinance, we certainly will. But that will keep the traffic coming on Saturdays if they're doing work inside. Painting is a great example. If we're looking to prevent that from going on as well, I think we're going to have to look at something outside of 20.
yeah. Bart, go ahead. I want to bring one other thing too. Might want to have some kind of clause in there, for example, commercial lawn mowing or lawn services that a lot of people have. Maybe we could for scheduled lawn service or something like that, without the hours or on the weekends. But let's say somebody had a tree fall down, or some circumstance that's out of the ordinary where you need to have people. They have to come on a Saturday afternoon or Sunday or whatever to do. I don't know what thoughts are on that.
So in this circumstance, again, you can ask for a variance of the noise, and so if they anticipated a lot of noise with taking down trees or whatever, they can ask Kathy, and that we do that fairly quickly. So if they're planning to do work on a Saturday and Sunday, they can come and ask like on Friday, and we can issue a letter allowing them to deviate from the noise ordinance because of this emergency.
I don't think I want to go there. I'm talking more if a tree goes down in their driveway, or blocks them on a Sunday or something.
Services.
I don't want to ask somebody to go get a variance or whatever. So it would be more of an extraordinary circumstance that
Right.
was something like that. But so we need to discuss who. Bert, did you have?
Matt hadn't said anything yet.
No. Okay, so I do have a question going back to what Longoria mentioned a while back. So we have some subjective language as well, but the mediation, I just want to know exactly how does that work. Obviously, I'm not familiar with the Fulton County Alternative Dispute Resolution of Fulton County Superior Court, so we have two individuals that might be going to mediation. If that's decided upon and they have a dispute afterwards, how does it affect our police if they have to go back to a door? I just want to make sure I know the process of that.
I apologize. I'm having trouble hearing.
Okay.
I don't know if it's a microphone issue.
The mediation aspect of the, can you explain how that works as far as if there's a mediation, when there is a resolution, if there's another complaint after that, how does that affect us? Just talk about that process.
I don't know the specific mediation program. Having used similar type, I assume, mediation programs, it's completely voluntary and non-binding. So you would just hope you'd get two reasonable people in a room that could work through a problem with an objective, non-attached third party mediator. I don't know that this is exactly the case with Fulton County, but that's been my experience. It's my best guess that it would be something
So
similar.
when I spoke to Paul Fricke, the other city attorney, we talked through that was just, the city wouldn't be involved. It's just an issue between two entities, because there's many times that we have issues between two citizens.
Sure.
And it's really an issue between those two.
Right.
It may not be an issue that we can really enforce from a noise perspective, but they're still really annoyed with each other, and it might be related to noise, but we can't issue any kind of citation. So that's
Well,
possible.
when private parties have issues of this kind, I don't have to tell you that these can become very intractable for local governments as they sort of get pulled into trying to be the arbiter between two neighbors that may not get along. And so obviously, to the extent someone believes that an ongoing use of property constitutes a nuisance, well, an individual property owner always has the right to initiate a nuisance lawsuit against their neighbor. Mm-hmm. But I think the objective of adding this language in was to at least give the city an opportunity to say, listen, before you go and haul off and file a lawsuit, there is, in fact, an informal method of dispute resolution where people can sit down together, have a detached and objective, dispute resolution arbiter or mediator, and hopefully save everybody the cost and hassle and expense of doing that by trying to work things out. Now, sometimes that may not work, and they may not take us up on it, but it is at least an option to offer citizens. I've seen the alternatives, and typically the rush to the courthouse is not going to be satisfactory to too much of anyone.
Ken, are you, in your experience, have you seen these mediations work generally? Not all the time, but most of the time, or? Just an honest question. Have you seen them work?
Well, mediation is one of those things that certainly it can be effective. It needs to be tried, and both parties need to show up in good faith. But if you're asking me generally if mediation can work, absolutely, it can. Now, have I seen it done a lot of times with respect to these sorts of neighbor-on-neighbor disputes? Not that much.
Law enforcement, we've had some luck with it, but it's always dependent upon the parties involved.
Anybody else? Robin, staff, are you hearing, can we clarify? There's been a lot of different comments, a lot of different things. Are we?
So I think that in respect to the Fulton County discussions, that's another situation, correct, that we can't really resolve right here.
I think, Robin, and I don't mean to be over-speaking you, I think we need to go back. We go back and listen to these quite a bit. I think we need to go back.
For us to digest these comments and take another look at it and let us review it too. Bill?
Yeah, just to echo what you've just said, I think each of the speakers, and Mr. Cox had a pretty extensive presentation too. I'd like to make sure we revisit each one of those points, and of course with the public school system too, I think that's very important.
Okay, and then amending, kind of working with the timing and with commercial versus the personal uses as well, the timing, right? And then looking at our other ordinances as it speaks to construction, actual activity, not noise.
A couple of things. So I understand the chart, but the chart is very confusing. So I would like to perhaps see something that says, whatever we titled, just pulling off the exterior, outside construction activities emitting noise, if that's what we have to do it for this, and then we look at other things for another code. But say it's allowed here and here. It ain't allowed any other time, versus it's this or this. Make it very cut and dry and clear. And then, I don't think we can do it tonight and be clear.
Okay.
Anybody else? Well, right.
Just one last clarification. Are we saying that I like the idea of till sunset for allowing residents to actually be able to, we talked about this with lawnmower. Were we pretty much concentrating with the hard times on commercial? That was my intent when I brought it up.
I can get there.
Yeah.
Okay.
I think so too.
That was my understanding.
Okay,
That's what I was
thanks.
doing, yeah.
Okay, so, I'll open up. Sounds like everybody'd be okay with the deferral on that. So I'll open up for it. What would be the reasonable time does staff think before we bring it back?
I mean, I don't think there's too much time of the essence on this.
It depends, I guess, if you want discussions with Fulton County before because that might.
I mean, we may be able to turn this around for the 21st, but we could also we could probably make this a complete package if we went into the first meeting in September. I mean, actually, I just put words in your mouth.
Yeah.
Take a little more time.
Well, if the issue is the researching the issue of whether there's any variation of our police power that could be applicable to the school system, I've already asked that assignment be done, but I'm thinking probably a week to get that back.
I mean, I could strike that section C3 if that turns out to be the case, or if it's not the case, we could obviously change our code to make sure if we do have powers there, we might want to figure out how you want that addressed, because you will have sporting events, and if we have any control over those sporting events and the noise that's emanated from those sporting events, obviously if it goes over a certain decibel level and they are subjected to it, just want to make sure that you want us acting the way you want us acting.
Okay. Yeah, I would say probably go a little further out if we can, just to get it right. Give everybody time to look at it. Bill?
Since we have this topic open at this point in time, and we're about to get into the UDC discussions, why not just take the proper time to vet this one out now so we can incorporate it into UDC when we get into that discussion? Just a thought.
Okay. We need a motion for a deferral.
That would be appropriate, Mr. Mayor.
And what would the appropriate time be, or do we Do we want to set a time, or do we want to, do we have to set a time, or do we want to?
I would prefer to have a time that, first meeting in September.
Okay.
Which is September 6th, I believe. It's a Wednesday.
11th.
11th?
Good. Okay.
I'll be back from vacation.
9/11, yeah.
Okay, I'll open up.
On the meeting and all the first.
And I was
When
just
did you
going
want to say
to Mr. Lusk's point about the UDC, at the next week, we're going to have an overview of the UDC, and I think we're just trying to keep the UDC to kind of the nuts and bolts and organization and kind of that type of thing, instead of dealing with changes to the actual ordinance and material changes. So, I mean, we can, obviously, if that's something you want to do, is to wait till the UDC, but the goal of the UDC is reorganization, not coming up with totally different ordinances.
I think Councilmember Lusk's point is, let's get this thing cleared up now before we get into the.
Oh, I thought it was the opposite.
Into
I'm
the
sorry.
before we
Oh, yes.
get into the
I
UDC.
agree. I'm sorry.
All right, I'll open up for a motion.
Make a motion that we defer agenda item number 17-170 to September 11th, City Council meeting.
Okay, I have a motion from Councilmember Kuntz to defer to September 11th, and a second from Councilmember Thurman. All in favor, please say aye. Aye. Any opposed? That's unanimous, Sudi. Sudi, if you'll please call the next unfinished business.
Next item is consideration of an ordinance of the City Council to authorize Fulton County to conduct elections. Agenda item number 17156. This was under first presentation at the July 10th regular City Council meeting. Mr. Ken Gerard.
Mr. Mayor, members of the council, you have in your agenda packet two documents. You have an ordinance. The ordinance authorizes the mayor to execute an agreement with Fulton County and the Fulton County Board of Elections that will authorize Fulton County to conduct Milton's citywide general election in November. This is specifically authorized by Georgia law for the city to contract with another entity like Fulton County to provide those sorts of services. And of course, this is not unusual for the city of Milton. We have done this before, as have a host of other cities within Fulton County. So this intergovernmental agreement, if I can have you turn the pages to the intergovernmental agreement, the actual duties to be performed are not unique. Again, you've seen this all before. However, I want to get you to the nuts and bolts of it, because that's what you want to spend your time on, and that is, of course, what is going to be the cost with respect to these elections. So it's anticipated there will, of course, be the general election, and there could possibly be a runoff. And Fulton County has provided what they believe is the budget for both of those. What they do then is they apply a entire countywide budget, and then they back out a certain percentage and assign that as our pro rata based upon our percentage of electors as to the electors of the whole Fulton County. So that's how they do the math. We account for, I believe the number is 4%, is what is considered to be our pro rata share. They have attached to the agreement a budget. And they've also tacked on a 10% administrative fee. That's right, they did. And so what the math is basically that they have come up with the entire cost of running all of these elections. They have then backed out our 4%, tacked on a 10% fee, and that is the amount that we will be responsible for. So the general election fee is $78,458.60, and then the runoff fee would be $66,982.30. And what this agreement provides is that we are to pay 75% down, if you will, on that 90 days before the actual election. And then after the election is over, they will then true up to see if their budget work was correct. If the actual cost was less, then they will refund whatever amounts we have overpaid. However, should the amount be actually more, then we'll need to pay our pro rata difference to make up the amount. So that's the way this will work. I don't know what staff have in mind, whether we're going to pay the 75% or just go ahead and pay the entirety of the 100% of their estimate of the $78,458 and the $66,982. But that is the way they have undertaken their math. And again, if the council is prepared to adopt the ordinance this evening, that will authorize the mayor to sign, and then we'll tender it down. Mr. Mayor.
I was just going to ask Stacy or any other staff, do you have any, compare that with what we've been charged in the past?
talk about the numbers? Do you know the numbers off the top of your head?
I don't know the numbers off the top of my head.
It's been a while. I was thinking.
But I believe
60
it's around the
around
same number.
60,000 or
60 to 70,000.
The only thing I just want to discuss, and I want to make sure, and Stacy, please jump into the conversation here because it's you and I that have been discussing this. We've been working through with the other municipalities trying to really redline the difference between this and the previous cycles. And to the best of my ability, our ability, what we can understand is odd versus even year. The odd years, when we are running, we're running an election, we'll be responsible for that 10% administrative fee. If they have a runoff, and please, Ken, correct me if I'm wrong, and we are not involved, we will still be responsible for that 10% administrative fee. Conversely, on even years, when we don't have anything going on, at least in this agreement, and this agreement only runs through the end of the year, keep in mind.
That's right.
This agreement does end December 31st of 2017, but then it goes on to talk about subsequent election cycles where we would be responsible. So it was a little confusing, to be quite honest with you, and I want to make sure we're landing in the right place.
It was confusing, and I believe there are some other municipalities that actually have a little higher costs that are taking this a little more seriously from the standpoint of wanting to perhaps push back with Fulton a bit. But the next time this comes up, there will have to be another intergovernmental agreement for you all to consider at that time anyway. So we can reconsider, if the council needs to, this 10% administrative fee and some of these charges. But at this point, I mean, we're almost 90 days out as it is right now, so there is a little bit of urgency to getting this in place.
So the risk would be entirely associated with if there was a situation in which there was a runoff in which we were not participating, we would still be responsible for 10%. The 10% administrative fee. So that's I mean, I don't know that we have a backup plan, but I just want you to be aware of that.
So I suggest paying only the 75%.
Yeah, I agree.
Yeah,
That's right.
I'd say that too.
That's exactly right.
Do you have to pay for the runoff? After
No,
decide if
you
there's
don't
a
pay the
runoff?
fee for the runoff, not
Until
the full
after
freight.
the initial election?
I believe so. Isn't that right, Sudi?
There have been years that we have not paid it. This year I did ask for a check for the full amount. But the difference is it was going to take them 120 days by contract to return what wasn't used. This agreement says 90 days, which is a lot better. So we went ahead and asked for the full amount to go to them.
Karen?
Now, I know when we had the green space bond referendum, we originally had authorized to pay Fulton County for that, and then Fulton County came back and said because they were already having an election, we did not have to pay any of that.
Right.
Is that going to be, do we have any idea, is that going to be their policy going forth, if they're already holding an election, or is it, we're going to always have to pay for it?
I mean, judging for what I'm reading, it doesn't appear that will ever be the case again. We would still be responsible for the 10% administrative fee, if I'm reading this correctly.
And if I could answer, I forget.
Oh, plus we would have to offset our pro rata portion.
Correct.
I think
So
that.
if we end up having a special election for some reason, we have to pay all that fee again.
But again, this is only through the end of the year.
But oddly enough, it talks about being in perpetuity. So I'm having a hard time. I mean, I know it only goes until the end of the year, but
I think they will want us to have to adopt another intergovernmental agreement before they ever do this again, because their rates, their budgets are always going to change. So they're going to have to come back to us again. Now, they will argue precedent. Once we do this once, that will be forever. What their expectation from us. And I also want to be clear. I forget who asked the question, but my reading of this now is it says that the city will pay the county the sum identified or determined in Exhibit B. And as I read B is both the general election and the runoff. So I think that is correct. I think their expectation is, and to Stacy's point, we will pay 75% of the total combined figures, and we'll pay that now. Basically, immediately upon you all approving this, we'll pay that now, send this down to them, and then just wait and see what the outcome is.
forecast a runoff, whereas when you pay that,
That would make a lot of sense. I suspect they just don't want to chase money. They want it in their account, and then they'll pay us back.
Take forever to give it back.
Well, they're supposed to pay it back within 90 days. Yeah.
So we do have to pay.
We'd pay the
75%. If we want to do it, 75% of the runoff fee in advance, as well as.
Yes, pay 75% of both. That's the way I've read
now.
this.
Okay.
Yes, and then just wait and see
What
what
was the
actually
other
occurs.
option? Pay 100% of both, or just the initial election?
Do you know the answer to that?
I'm sorry, Mr. Mayor. What?
The other option was to pay 100% of the estimated cost. Would you have to pay that on
Yes.
the runoff too?
Yeah, the bottom line is obviously, to Stacy's point, it makes no sense for us to pay 100% of the entire amount. Just pay 75% of both.
True up.
Because the reality is, if the actual amount of even just the general is more, we would still owe additional amounts anyway. So it's likely it may not be as big a swing as we think it is.
And I guess bottom line, we're getting the money back. We'll have the dollars trued up. It just takes 90 days.
That's correct.
Okay. Anybody else? Matt?
Stacy, we got the $120,000 in the budget to write the check? I assume so, but
This is going to be next year's budget.
next year's budget.
So we're prepaying it now, so it'll
Right.
fall into next year's budget. So we will have to obviously budget for those numbers in fiscal year 18.
Okay.
So to be clear, we're getting word of what I would say is a slight cost increase from a single source vendor less than 90 days from the time that we need their services. Do we have any negotiating options here at all?
Go to mediation.
Rory, here's what I think. I think that right now we probably do not. But I think that if the cities come together collectively and believe that this is so onerous that they don't want to do it again, or they feel like we're becoming a cost center for Fulton County, that it may be something we look at for the next election cycle.
Yeah, we've talked about that. So.
Yeah.
Okay. I'll open up for a motion.
And forgive me, Councilmember Hewitt, please.
I make a motion to approve agenda item 17-156.
Second.
Okay, I have a motion from Councilmember Hewitt, and I apologize, but I'm going to say, I think Councilmember Kuntz, something like about the same time, a second. Is there any discussion? Does anybody want to discuss something while Bill, I don't know if Bill stepped out.
I think we'll be okay.
All right, hearing none, all in favor, please say aye.
Aye.
Any opposed? That's unanimous. Councilmember Lusk is not voting. Okay. We'll move to new business. Judy, if you'll call that item.
And next item is consideration of an agreement with the City of Milton and Gas South for economic development purposes. Agenda item number 17204, Ms. Sarah Ladart.
Good evening, Mayor and Council. What we are talking about is a alliance partnership agreement between the City of Milton and Gas South. In return for us having Gas South as a preferred provider for the city, they will be giving the city $12 for each new residential hookup, $24 for each new commercial hookup, with a $1 per month loyalty payment to the city for each residential and a $2 per month loyalty payment for each commercial customer. So it's a revenue generator. No other utility at this time has asked us to participate in an agreement like this. This is not an exclusive agreement, so in the event that another utility company were to come and ask for something like this, we could go out to bid with it. And also on top of the incentive payments, if you sign up, Gas South will be offering you discounts not available if the city doesn't participate in a program like this, and they will start partnering with us on more of our events throughout the city. And so some of our neighbors already participate in this program. Kennesaw, Woodstock, Roswell, Sandy Springs, they all participate with Roswell, telling me they get like $40,000, $50,000 a year. So we could anticipate maybe $10,000 a year, relative to size. And I would like to see that money go to the community outreach department, being that this is money generated from our residents signing up for this. They should be receiving the benefit of the money, and we can always use money in community outreach.
I have a question. Maybe Ken, just think this through to make sure, and I understand it's not exclusive and whatnot, but could this be taken by some citizens that, you know, if we're getting a rebate or something like that, that technically they're having to pay additional for their service?
Yeah, I mean, I think to the extent you're asking, is that what a citizen could believe? Sure, I think though the reality is if they're not happy with the price that the vendor's providing to them, that they certainly have the ability to vote with their pocketbook and take their business elsewhere. There are examples of this in other governments where you basically provide very de minimis, you know, sort of partnership opportunities, and in exchange for that, you get the jurisdiction, get some funding back. So this is not unique to either this particular service or to the city of Milton, but Mr. Mayor, of course, someone may think that, and someone, in fact, may pass on the opportunity to use this provider for that very reason.
Well, and yeah, not poo-pooing the idea and all, but just want to make sure.
Sure.
I guess it makes sense if the customer has the option of, you know, competitive bidding and go out and get other prices, and they don't have to elect. It's not that, unlike sometimes like the power company or whatever, where that's
It's
your only
exclusivity,
thing you
right,
use.
right.
And when I brought this to Steve and had Gas South come in, Steve had me look at where they fall in line with the other gas providers, and it's all within a couple pennies. So it's not like we're partnering with the most expensive or the least expensive.
Okay, yeah, and it's nothing against Gas South. I just want to make sure that the perception for our citizens. Matt?
Yeah, I kind of have a problem with this. Nothing against the idea as far as it goes, but you know, the question becomes is what is the role of government? And you know, taking classes in GMA with regards to public-private partnerships, you know, there are situations where it makes sense, especially when then there's a hardship where the citizens really have a need. In this particular case, I don't really see that as being the case, and I just don't feel good about having the idea of a company piggybacking off of our influence for advertising dollars and then paying us back in that where we get discretion to that, when really I think that I'd rather see they pass those cost savings off to the clients directly. It really is one of those questions of what is the role of government, though, from my perspective. And, you know, this is one we're just not so comfortable with. So I just had to say that.
Okay. Karen?
You did say, though, that if we do this partnership, the Milton residents would get some kind of preferred pricing that they would not normally get. So there is some benefit to the residents. Why don't all the other gas companies do something similar then?
They think they can get more clients this way through us, so they can lower the prices. That's what
Gas
it is.
South is the only one who's approached us about doing it.
Do we know if any of the surrounding jurisdictions have agreements like this with other? Because I would feel much better about doing this if we were doing this with 4 or 5 different people, rather than doing this with just one. That's what bothers me a little bit.
Right. So in looking at it, I didn't find anybody else who had sort of agreement with any other gas or utility company. I'm assuming that's because they don't offer it, because why wouldn't they approach us if they wanted us to participate in something like this?
And would you list the other neighboring cities that do this?
So all of them: Ackworth, Kennesaw, Woodstock, Roswell, Sandy Springs, Norcross, Lilburn, and Smyrna all participate.
Okay. Rick? And then Joe.
Yeah. To Karen's point, I under Gas South responsibilities, I read that both existing Gas South customers and new customers that sign up would get a 2 cents per therm over the advertised rate. So they are getting something by going to Gas South. Even if they're an existing customer, they put in this promo code from the city. Okay.
Joe?
Did Gas South tell you how many customers they had in the city of Milton currently?
No. Do you know that, Mark? Yes.
And the reason I'm asking is...
We do have a representative from Gas South.
Yes,
so be glad to allow
I was going to
speak.
say, all gas comes from the same pipe. All gas comes from the same place.
But they're buying.
Gas companies just market to get customers and manage customers for the real gas company.
Right.
So...
Sorry, Mark Goodman with Gas South.
This is the, what the current,
Okay, so they approximate 9,700 residents and 246 commercial in Milton.
That's existing.
well, that's how many total. I don't know, I can get you, I don't know how many are currently customers, but that's how many potential folks that are here in the area in the Milton and service territory.
Okay. Any other questions?
It sounds low for some reason.
That's households, though.
Yeah.
Huh, okay.
Some of us don't.
Well, I think
have
it's
gas service.
a good idea, that we can benefit some from it. And as you said, it's non-exclusive.
Right.
People have a choice. It's not like Joe said, it's not like you only have Georgia Power or Sony. So I'm in favor of it. Anything we can get money in.
Again, that was my biggest concern was if someone was locked in, but if they have the option to choose their service and they're still getting a good, the best deal they feel, as well as to your point, Sarah, it does actually come back and help the community. It goes back to the citizens. So I'm okay with it.
This is
Hold on, Jim. Bill?
I'm not so sure that Georgia Power and Sawney and Walton is a good comparison. I think that the electrical utility is constrained by different districts.
That was the point. Whereas the electrical, you don't have a choice. So if we did some, you can only call
Sony
or call BMC.
I missed it.
Yeah, no, that was the point. Joe, did you?
No, I was going to say that opting in to the program, I think, makes money available that would have just been kept by the company otherwise. So it's not like this money was going to be rebated to our customers and they're paying extra for us to participate. We're just getting the benefit, which we can pass back to our citizens that they wouldn't otherwise have had.
Right.
So.
Okay, Beth Karen?
They have these agreements with a lot of the colleges and universities and it's not just municipalities that they have it. So they like to be the preferred provider with other large groups also.
Okay. Matt?
Just kind of a legal question. So obviously if, we're tied in from an advertising perspective, something wrong happens, Ken. So what would be our liability in something like this? Obviously I read the as far as this goes, but I wanted to make sure that you haven't seen scenarios where there could be a unintended consequence that we may not be considering.
Right. So there would be no liability. I mean, we're a preferred partner, but we are not in any way sort of a joint partnership in the delivery of their business. And so to the extent that there is some sort of a technical issue or, heaven, God forbid, there's some sort of an environmental or even a public safety issue, I do not believe that the city of Milton would have any liability whatsoever.
Okay. Anybody else?
Just last comment. It looks like under here also that part of this agreement is we could evaluate this with an annual meeting to say, is this working the way we thought it was intended? Are there benefits for us as a city? So we're not locked into it. And they put that actually into the agreement.
Anybody else? No, I'll open up for a motion.
I make a motion to approve agenda item 17-204.
Second.
Okay, I have a motion for approval from Councilmember Hewitt, second from Councilmember Morrig. All in favor, please say aye.
Aye.
Any opposed? You have one nay. Councilmember Koontz, City, and 6 affirmative. Okay.
Thank you.
Thank you, Sarah. Thank you, Mark. All right, moving on. City, will you please call the next new business item? And then we added one more. So.
The next item is consideration of a separation agreement and full and final release of claims between Tom Brown and the City of Milton. Agenda item number 17205. Mr. Ken Gerard.
Mr. Mayor, members of the council, this is a separation agreement that we had previously discussed. I think as we had discussed the last time this was gone over with the council, we do have to bring these out in an open forum, and we do have to go over the material and substantive components of the agreements and then ratify them prior to them becoming effective and binding. So this is a separation agreement and full and final release between the City of Milton and former employee Tom Brown. You'll note in your agenda packet, you'll see basically 2 provisions that I want to go over. Number 1 is the settlement Mr. Brown and the city wish to settle fully and finally any and all differences and disputes between them, including but not limited to claims arising out of Mr. Brown's employment with and separation from the fire department and the city. And then number 2 is the consideration. Of course, that is the exchange of value that has to be demonstrated on the face of the agreement. Mr. Brown covenants and agrees to waive and release any and all claims related to his employment. And of course, the complete release and waiver is set forth in identified paragraph 3. I won't go over all the claims, just understand that it is complete and comprehensive. Mr. Brown and the city covenant agree that, and these are the 3 elements that I want to bring to the council's attention before I end my presentation. Mr. Brown has elected to voluntarily separate from his employment with the fire department and the city, which separation shall become effective upon Mr. Brown's execution of this agreement, which I believe has already been executed. B, upon Mr. Brown's separation, Mr. Brown will receive compensation for his current paid time off balance in an amount not to exceed 318 hours to be paid at Mr. Brown's regular hourly rate of pay with the appropriate payroll deductions, and the city will purge Mr. Brown's personnel file in accordance with OCGA 45.1.5 within 30 days and place a notice of that purging in the personnel file. Mr. Mayor, those are the substantive and material parts of this settlement agreement, and the City Council is available and can adopt at this time.
Okay. All right. You're welcome to ask any questions. If not, I'll open up for a motion.
I'll make a motion that we approve agenda item number 17-205.
Second.
Okay, I have a motion from Councilmember Kuntz, second Councilmember Thurman. All in favor, please say aye.
Aye.
Any opposed? That's unanimous. Okay, Sudi, if you'd please bring up the next new business item that was added to our agenda.
And we added a item, a joint property acquisition on park property between Alpharetta and Milton.
Okay, and I don't know, Ken, if you're ready to speak on this. Or
Mr. Mayor, I am. Just one second. I'm
Okay,
just looking at the documents before I begin to go through them.
It costs us anything. Just give us free money.
The council, just if I can just have a few more seconds with the city manager.
pull up all three.
Can you put a tax parcel? Is there a way to do that, or any sort of yeah, there you go. All right.
So that's 1470. 1470 that's highlighted. 1480 is the small one in between, and 1490 is the right-hand parcel.
All right. All right. Mr. Mayor, members of the council, if you can, this is the agenda item that was added by way of a motion to the agenda. This is, in fact, 3 different acquisition contracts that I am holding right here and will give to the clerk later. These are contracts that I have reviewed. I have definitely reviewed one of them, and the other 2 are the same. And candidly, they're based upon models that I had assisted the city of Alpharetta with, their city attorney. So let me go over them with you very quickly, the nuts and bolts of them. The first one pertains to 1480 Mayfield Road. If you could pull 1480 Mayfield Road up. Let's don't do that one first, Carter. That's my fault. Let's do 1490 Mayfield Road. We're going to do 1490 Mayfield Road. Let me go over the terms of this agreement with you. First of all, with respect to 1490 Mayfield Road, the sellers are Creighton Fuller and Patricia Fuller. So those are the sellers. The parcel is 5.383 acres, known as Fulton County Tax Parcel 22 4480 1103 0819. And again, the street address is 1490 Mayfield Road. This is property that the city of Milton is acquiring in conjunction with the city of Alpharetta that will be used for some sort of a joint venture park and rec facility. But the parcel will be purchased for the price of $750,000.
And to clarify, that's City of Milton's part.
Well, I think the combined 750 plus 750, the city of Milton will basically pay 750, and that will be our contribution for correct.
So just to make sure it wasn't public, there wasn't any.
Right. Our total exposure is $750,000 for all of the parcels here. So we do have a $10,000 earnest money obligation, which we will pay shortly after executing these agreements, followed by a 60-day due diligence. During that 60-day due diligence period, we can get out of these contracts for convenience. If we, in fact, trigger that right to get out of these contracts for convenience, we receive our earnest money back. It will be repaid back to us. During the due diligence period, we, of course, have the ability to go on the property. I anticipate we may get a formalized survey. Obviously, we'll conduct and get title insurance and a title opinion to make sure that we're going to get good and reasonable marketable title. And then once the due diligence period closes, we lose our right to get out of the agreement for convenience, with the expectation that there will be a closing 30 days after the end of due diligence. I'm very comfortable with these contracts. I've used them many times before, including in the city of Milton to acquire property. I will tell you, though, that with respect to this particular parcel on 1490, there was an addendum that was added to it. If I could, I do need to go over that addendum with you. The addendum was prepared by the seller. Sellers shall reside on the property. They say rent-free and tax-free, but however, this addendum anticipates a formalized lease, and I will address that rent-free, tax-free language in the lease that I'm going to work with. I do not have a lease for you today. I've received it from Alpharetta, but I have not reviewed it yet. The seller will reside on the property for a period of up to 12 months after closing, provided that sellers shall enter a lease agreement with the buyers, which is exactly what I anticipate will happen, and that I will bring a lease that I'm comfortable with to you at some point. The seller will agree to maintain the property and pay all utilities while they reside on the property, which of course would be our expectation. Prior to vacating the property, the sellers will be able to remove any fixtures from the home or outbuildings, provided that sellers shall not remove any doors, windows, or other items that would cause a security issue. Sellers shall be able to remove 2 structures as identified on Exhibit B, as well as fencing, also as identified on Exhibit B. This addendum I have not reviewed before, council members, but I tell you the references to Exhibit B, I don't think they mean Exhibit B. I think they mean Exhibit A1. And I will go over that with you if we choose to approve these this evening. Sellers shall be able to leave any items in home or outbuildings or other structures. In other words, they want to be able just to vacate the property and not take anything, and we're okay with that. And finally, that the buyers, meaning us, the city of Alpharetta, will give sellers 24 hours prior notice prior to entry upon the property. Obviously, while they're there, they just want to know before we send crews to come in and begin to do our due diligence or what have you. I don't think that's a terribly onerous or burdensome requirement. So that is, in fact, the agreement with respect to 1490 Mayfield.
I have a question, Ken.
Of course.
We will actually own all of the structures on the property and all the improvements, correct?
That is correct. We will own everything.
Who's carrying the liability and property damage insurance during that period?
Well, they will have to secure a tenant policy of insurance is what I expect the lease agreement they've put in place has. Now, after closing, Councilmember Lusk, after closing, typically the burden of insuring all those structures, et cetera, falls on the owner, which would be the city of Milton and Alpharetta. Right. And you have raised an issue we also at least ought to talk about within the context of acquiring these properties, and that is, at some point, the city of Milton and Alpharetta need to come together and come up with sort of a maintenance and operation agreement as well, as this is going to be a jointly owned piece of municipal property, and we've not done that yet. But after it closes, I anticipate that staff will work with the city of Alpharetta, and we will, in fact, have to insure the piece of property like we would any other piece of property, subject, of course, to the tenants remaining on the property.
Well, are we obligated, and I say we, the buyers, then to carry insurance on those structures there if they're renting them or leasing them in a free status? And I guess it's one question. The other question is, have we done a survey of all of those structures to determine in the long run if we're going to use them as a part of it?
I think that we've had some staff view them, but I don't know if we've made a determination as to whether any of them are worthy of long-term retention or not. Yeah. Going back to your question, though, Councilmember, the question you're asking, though, is once we close and ownership of the property to include the improvements is conveyed to the city of Milton, would we have an obligation to insure them? That is probably something I will go over with staff, because I don't see any reason why the city of Milton should insure structures that we may not keep long-term. However, if there's people living in them and we have a landlord-tenant relationship with them, somebody is going to have to insure them.
Right. Well, let me ask a question at that point. At some point, I know we've got in there, they have to pay the utilities and all, and could that be, we can check the rates and all that. It probably, if it's like a typical, residential house, it wouldn't be a whole lot of money to insure it. But is that something where that could be negotiated with the tenant, that they pay utilities and the rental, the insurance on it?
It is, and so this is one of the negatives of me not having a deliverable lease to give you right now, and so I've just received the lease. What I will commit to you is during, particularly, of course, during the due diligence, when we have the ability to get out of the contract for convenience, if I can't get to a comfortable place with respect to the lease, I'll tell you. But my expectation would be that there would be a tenant's policy of insurance, that they would insure the structure they're going to live in, that they're going to pay the utilities, that they're going to waive us and exonerate us completely from any liability. Heaven forbid one of them trips and falls on property we now own. So all of those issues I will have to deliver to the satisfaction of the council and my city manager, which I will do. I just don't have those answers for you right now.
Okay, that's important. Okay.
Typically, it's hard to get insurance on a property you don't own other than renter's insurance on the contents and everything else. So I think this is a big issue we need to look at, because we want to make sure that, if something happened to the property, not the contents, which they clearly they will be insuring, but the actual structures themselves, or somebody getting hurt at the property, we don't have any liability.
Well, the issue of whether or not if they get injured on the property that we own, because we're allowing them to remain there, I can draft around that. To the extent that they're going to have difficulty getting other than just a tenant policy of insurance, which I don't disagree with you on, it may be that we just agree that there's going to be no insurance other than for premises the typical premises liability, but there's no insurance on the structure, because I don't think the city of Milton has any interest. Well, how about this? I'm not sure the city of Milton knows if we're going to maintain that structure on the property, we maybe could do our due diligence and decide to raise it.
Well, that's probably the case, but to, on the contrary, maybe there is some use for one and you wouldn't want something to get torn up or whatever. I'd almost suggest, during our period we have, if our staff can get together, number one, and find out what it would cost to insure it. If it's $1,500 for a year in between City of Alpharetta and Milton, it may be, we may think it's worth $750 to insure it, if we may want to use the building. But also, I think the key, and everybody else has brought up, it's the liability. We want to make sure that, we're covered on liability. Somebody get hurt.
And if something did happen to the structure, if they've got a lease to live there, would we be responsible to rebuild so they could live up to the 12 months? That's where, without insurance, I think we'd be exposed.
Well, I can tell you what I'm thinking right now. The answer is that no, we're not going to rebuild anything if for heaven's sakes, they burn the place down inadvertently, mind you. But if they burn the place down, I don't want the City of Milton to be on the hook, or Alpharetta for that matter, to be on the hook to replace anything. But those are
the verbiage that they're, we're leasing it to them as is.
Yeah, as is, where is, yes.
Is this the only one that's going to have any retention of the three? All three will.
All three.
Yeah. Which is a nice segue into the next one, which is, if I can, that was 1490 Mayfield for the record. This is 1470 Mayfield. This is a 5.393 acre. Carter's got that identified. This is tax parcel 22448011030306. Sellers are different. Sellers are Jerry J. Anderson and Linda C. Anderson. And the purchase price, once again, is $750,000, of course, subject to the stipulation we went over the first time that we're only responsible for $750,000 of this combined amount. The due diligence is the same. The earnest money is the same. The closing date is the same. The details in the contract are the same. Let me see if there's an addendum on this one. And the answer is there is an addendum on this one, and it's the same exact addendum that I just went over with respect to the other Mayfield property. So that's now, we've gone over 1490, and now we've gone over 1470. The last I want to mention to you is 1480 Mayfield. If you can bring that one up on the screen, I think that's the small chunk in the middle. All right, so the contract is going to be the same. So it's going to be, first of all, the sellers for 1480 Mayfield are going to be Jerry Jefferson Anderson and Murdy, M-Y-R-T-I-E, Murdy Patricia Anderson Fuller. Those are the sellers. The parcel is 1.734 acres. The street address is 1480 Mayfield Road, Fulton County Tax Parcel 22448011030827. This property, however, will be donated. So obviously that's significant. So we've got the two 750 tracks, and then so the middle donut, if you will, is going to be donated, which of course takes away the earnest money requirement. But all the other stipulations as to getting fee, title, and the ability to get out of the contract for any reason during the due diligence remains the same. There is an addendum. It's one paragraph. In return for donation of the property at 1480 Mayfield, the offerers, which I think should be translated into the proposed sellers, request consideration that any future park be named in remembrance of the Mayo Jefferson and Flora Lee Anderson family. It's just consideration. You're not binding it by agreeing to this. Okay, and then of course they've got the same addendum attached. I just found this one, the same addendum attached. So, Mr. Mayor, members of the council, three parcels, 1480, 1470, and 1490 Mayfield. The amounts of money, I believe, are what we have talked about. I do not have a lease agreement to bring to you for all those. That'll be something I'll work on during the due diligence period if the council wants to go ahead and authorize the execution of these documents. I know that Alpharetta would like to get at least the agreements executed so the due diligence can begin. Because these are being bought for park and rec purposes, state law requires we conduct at least a phase one environmental on the pieces of property, which we'll do during the due diligence period. Otherwise, we'll go ahead and shoot a survey. And do we have one, Carter? Do you know if we have a recent survey or one we're comfortable
Not that I've
with?
seen.
And then, of course, we'll go ahead and get our title work done. But, Mr. Mayor, that's it.
You know, I'm fine with this, but, you know, obviously like for you to update the council within our time where before we can back out of it.
Of course.
If I go ahead and execute this now, but keeping in mind that we do still have the availability to get out for no obligation, but, you know, some of these things with the lease and all that, to make sure we're comfortable if we keep everybody updated on that. Right.
I think Karen first.
I'll call you first, and then I'll
Okay. Question on the first one, did you state that there are some buildings they want to remove or they want to take with them?
Yeah, that's right, Councilman Moore.
Is that the same on all three of them?
Yeah, it's in all of them. The same addendum. Sellers shall be able to remove 2 structures as identified on Exhibit B. And I think I mentioned the first time around that I'm not of the mind that Exhibit B is what they mean. I think they mean Exhibit 1A.
So they've identified the 2 structures per...
I think we've got an email a few weeks ago. We did.
They haven't. What they've identified is they've identified this plat, which identifies various structures, and what they're basically saying is within the universe of structures identified, they want the opportunity to remove 2 of those structures.
I think a couple of the pictures you sent, it would be welcome for them to remove any of the structures.
just getting the materials. So, Karen?
In order to accept the donated property, there's certain IRS forms that will need to be completed. Is that going to be our responsibility, Alpharetta's responsibility? Is that all going to be done jointly, or has that not even been?
We will have to work that out as we get closer to closing. I am familiar with what you're talking about, and I'm sure they're going to want all the requisite...
You're going to have the appraisal and everything else.
All the requisite IRS.
Right.
Yes.
Yeah, it's got to all be done and signed off on. And this is a little unusual because they're donating it to 2 charities, or 2 rather than
2
just
municipalities.
One. Yeah. So I guess we just need to make sure who is going to be responsible, because you sure don't want to miss.
We don't, and you know, when we were getting ready for these, when we first had some of the preliminary discussions with these, we sat down with some of the folks from Alpharetta, and I think it might be a good idea on the other side of contract execution to do that again, just to make sure no ball gets dropped.
Okay. I'll open up for a motion if there's no other questions.
Mayor, I'll make a motion that we approve the purchase agreements on the parkland with Alpharetta. Agenda item number, do we have an agenda item number for it? Do we add an agenda item number? 17206. 17-206.
Councilmember Thurman, before you draw a second, are you agreeable that any reference on the addendum to attachment B would be modified to refer to Exhibit A1?
If that's what you believe it should,
I
yes.
believe
I
it.
don't have it, so I don't know, yes.
Take my yes, I believe that's what it's supposed to be. Thank you.
Okay.
Second.
Okay. I have a motion for approval of Councilmember Thurman as clarified by Ken, and a second by Councilmember Warwick. All in favor, please say aye.
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 Any opposed? That's unanimous. Okay, thank you, Ken. All right, council have anything they want to report on before we move into staff reports? Okay. I'll move on over to Public Works. Okay, we'll move on to...
Yes.
Missed it by that much.
It's close.
Let's see, before I get into our T-Splost update, I wanted to follow back up with the Batesville 372 discussion that we've been having with 372. Their current traffic counts indicate 750 left turns at their peak hour, which is an incredible number of turns. If you put that in perspective, northbound ramp in the morning at 400 and Windward Parkway has 1,100 left-hand turns, and that's a triple left. So, or going to soon be a triple left. So the left turn lanes that they're dealing with, or the left turn volumes that they're dealing with, there are a tremendous number. The funding that they had been looking towards, which was quick response funding, has a $200,000 cap on it, and they don't believe that's going to be sufficient to deal with the modifications that will be necessary at that intersection. So they're doing 2 things. One, they're going back and they're modifying or checking their counts. So they're going to recount that, which they couldn't do during the summer. So once school is back in session now, they're going to have recounts done just to verify that that number is a true number, an accurate number. And they're also ordering a survey of that area so that they can determine whether or not they can make any improvements within the existing right-of-way or if right-of-way acquisition will be necessary. Under those quick response funds, they can only be used for construction dollars, so right-of-way acquisition, if necessary, and this project would have to come from some other pot. So they are still looking at the issue and moving forward. As we continue to have our monthly updates, I'll update you with any schedule and any information that I get from GDOT on that particular project.
Say again, which intersection?
That's the Batesville and 372 intersection as it impacts the roundabout operations. Moving on in our T-Splost update for the month, our collections have continued to go up. This month we were $498,916, which is getting closer. Our anticipated revenue from the Georgia State study for this month was $564,000, so we're inching our way closer. We have a cumulative a little over $1.4 million in our T-Splost funds, which is about $280,000 less than what we had anticipated at this point, but it's continuing in the right direction on that. We've issued an authorization to proceed with the design of our first two projects. That would be the Mayfield-Charlotte intersection and the Charlotte Road extension over to the east side of the roundabout, right there in front of Strawberry Fields. So that project will be getting underway. They're scheduling survey work for that now. So we anticipate survey to begin probably the end of this month, beginning next month. The other project that is included in that is our first batch is the Hopewell at the Bethany's intersection improvement. This one you'll remember we looked at a couple of years ago in our concept plan for we looked at signalization of both of those intersections. We looked at a couple of roundabouts, and then we looked at a center roundabout at that location, and we'll once again kind of go through that same concept plan. I think staff's perspective was that the single roundabout in the middle was probably the preferred option, both from a cost standpoint and from an operation standpoint, not only with the two intersections at Bethany Bend and Bethany Way, but with subdivision that comes out right in the middle of the two. The name escapes me right now, but overall probably the best operationally, but probably a more advanced roundabout that we had hoped to have some in operation at that time. So now that we've got, what do we have, 3 operational now, 2 more under construction, but some of those more advanced designs would be a little bit easier to swallow from an operation standpoint. So that one's moving forward with the first one too. Our paving program here will begin hopefully within the next 3 weeks. We're looking for a schedule from the contractor now. We awarded that contract to Bartow Construction a couple of weeks ago. They've been doing some utility locates. The paving program that you see on your screen here, the brown lines indicate projects that we've completed in the last 6 years. The blue lines on this one, if you can see them, just to give you an idea about the distribution of the paving this year, the blue lines indicate our patch and pave or full depth reclamation. So we've got full depth reclamation going on Taylor Road, on the southern half of Taylor Road. And then our patch and pave on our major roads will be some work on Hopewell, Red Road, Bethany Way, Long Street, and portions of Freemanville and Hopewell Road. Then we've also got our residential paving program that will be going in a number of different neighborhoods also. The pink lines on this map indicate another portion of our pavement management program. These were surface treatments that were done probably 2 to 3 weeks ago. So the surface treatments are roads that we do an application of a rejuvenator in the early stages of a road. So within a couple of years of being paved, we'll come back and apply those. We get a pretty high bang for our buck on that type of application, and we'll see if that has some long-term benefits for us too in our overall pavement management program. Just a quick update on our Mayfield sidewalk program. This is the sidewalk programs from the main intersection program down to the library. We believe we have finally worked our way through the administrative components of that, and will be heard by the GDOT board on August 17th to authorize us to advertise for construction. So we are finally moving forward in construction on that, we hope, here in the next couple of weeks. And with that, I'm done, unless you have any questions for me.
Any questions for Carter? Bill?
What's the status of Baldwin's project out here?
Oh, well, I was pretty excited that they got the intersection at Itasca done and Heritage Walk in front of City Hall here within the time frame that they said, and before school started. So that was a step in the right direction. At this point, they're working on some utility. They're working on water line connections. I think they've started on the roundabout here at Crabapple Chase subdivision. And then they'll be working on some water line work over at the other roundabout location before they start any of the actual road work on that. I don't have a schedule for you right now on when that activity is going to be complete, but I can bring that to my next staff report also.
So we're still looking at year-end for final completion?
No, I don't believe that's the case. I believe it will be probably mid-year next year by the time they get complete.
Does that take into account that they take 2-month-long sabbaticals? Just a...
Yeah. Point taken.
I'm sure they're not doing anything.
I'll make sure to pass that sentiment on.
Okay, any other questions for Carl? Thank you, sir.
Thank you.
Next is fire.
Mayor, Council, thank you. On Thursday, August 3rd, the fire department responded to the Walmart on Windward and 9, reported an electrical fire in the electrical room. When crews arrived, the fire had extinguished itself, but created some smoke and hazards within the structure. They were evacuated. All the people were evacuated. No injuries. Everything went fine. The fire department worked closely with Walmart to try to get them back up and running, just due to the economic impact that store has on the community. They had to shut the store down on Thursday, but Friday morning they were able to open the store back up and operate during daylight hours because the electrical system took out the lighting but did not have any effect on any of the freezers or refrigerators or anything where the food was. So we were able to help them, get them back online during the daylight hours, and they held a fire watch during that time because the exit lighting and all that was affected. And then by Saturday morning, we had them back up in line. They had their electrician in. They replaced the electrical panel where the problem was. And by Saturday morning, they were back up, open 24/7 again. So a good job by everybody involved there by working with the Walmart and the city and getting the inspectors out there as quickly as possible to help them get back. The other item I have is that last month, our fire personnel had an opportunity to visit the MDA camp down in Middle Georgia there where the kids go to summer camp, and that's where all our dollars that we collect during the year, it sends those kids to a summer camp for a week. So they have a first responder day, and it's basically just a big water war between the kids. They get to have fun. They get to, use the fire hoses, get the firefighters all wet. So we were able to send some folks down there to actually see where the dollars go and what the impact has to those kids. So it was a good eye-opening experience for them as well. And the last thing I'd like to do is I'd like to introduce firefighter Anthony Del Campo and his dog, Rio. Anthony is a handler, and he's a Georgia Search and Rescue participant, him and Rio, and what they do is they respond to search and rescue events throughout the state. The GSAR team and group actually pay for everything for Rio, as well as Anthony and his training and Rio's training as well. They pay the vet bills, the food, everything that's involved in that. But I'd like Anthony to go ahead and explain actually what he does and how he brought that to Milton and what he can do for Milton here.
Okay, so hello. So the way I started off with this is I started off in California. I'm from California, originally native there. And I've been doing it for about 4 years now. My dad does it with the sheriff's department, so it's kind of like a family thing. And I do have another lab, but she's 8 years old, so she's kind of getting ready to retire. So I brought up Rio, and I started training in Dawson County, where the Rebel Pile is. And that's basically, we do training twice a week. And down in Perry, Georgia, we go down there, and then they're building a rubble pile in Forsyth, Georgia as well. And I brought it to Chief Edgar that I feel that this specialty would be good to not only the city of Milton, but surrounding cities, and as well as the state of Georgia and other states, utilizing a search and rescue dog. And like about a year ago, we had a missing child in Alpharetta and an Alzheimer's patient in Alpharetta that was missing. And I felt that when I heard that go over the radio, they were attempting to locate, and they couldn't find both of those victims. At first, they did initially, but we could have utilized this dog at that time. So that's when I brought it up to Chief Edgar, and he approved of it. He went with this city manager and asked if this would be a good idea, and it was approved. So
That's great.
that's it, pretty much. You have any questions?
Any questions? Just want to say.
Rio comes to work with Anthony
Yes.
on his 24-hour shift. So the dog's available when he's here, and then in the event that there's a call out or we need him when he's off duty, he will respond, and then GSAR takes care of him from that end.
Yes, and we do have a total of 6 dogs on the team. So if, let's say I'm on vacation, they're more willing or more happy to respond as well. We were down south when the hurricane hit, and when the tornado hit, there was a lost child there that they couldn't find, and one of the dogs that actually found out where the child was. And we're here, we get called out. I get calls to Dawson County all the time, and there's always people missing, hikers or whatever it is, Alzheimer's patients. So it does happen.
That's good. Yeah. I just want to say, Anthony, I'm sure on behalf of the council too, thank you very much.
Thank you.
Thanks for Rio and the other dogs, and what a great not only benefit for City of Milton, but also, as you say, you get calls to our surrounding cities, our neighbors. And what a great reflection that is on Milton, too.
Yes,
to be able to help out. So
and
we're proud to have you here.
Yeah, and I'm glad to be here. So, and I plan on being here for a long time. So, I don't plan on going anywhere. So I think it'll be here for a long time. This service will be in the city of Milton. So
good deal. Well, thank you very much.
And I appreciate you guys all having me come here. And
How old is Rio?
he is 14 months.
Okay.
14
He's
months.
still-
So.
Pup.
And he's
Yeah.
still a pup for
Yeah, he's still a pup. So,
Black Lab.
yeah.
All right. Well, thank you very much. Thank you also, Chief. Thanks for everything you guys do.
Yeah.
All right, Bernadette, can you top that? Can you bring a dog?
Do you have a bunny or anything?
It's exciting.
I should have been better prepared. They tricked me. Good evening, Mayor and Council. I'll make it short and sweet. As you probably know, the assessments for 2017 have gone out. We have our 45-day wait period until we hear back for all the appeals, and then the digest will go forth through the county and then the Department of Revenue, and then we'll be able to bill. We're still hoping for that October bill date, but I'll keep you up to date as we go along. Finance has also been working with the city manager and assistant city manager on creating the FY18 budget request. We have met with all the department heads over the last few weeks, and Stacy will be bringing forth the initial draft next Monday in the work session. And you will see the budget along with the FY17 amendments in September. Additionally, Finance has been working with the Economic Development Department to review our business license ordinance. We're trying to look forth to try to be a little more business friendly and look at our small businesses and see what we can do for them to create a better working environment. And lastly, I brought forth, as has been asked in the past, the impact fees. We have received 49% more this year than we did last year. So we're at $1,111,960. Anything else? Questions?
Any questions? That's good. Thank you very much.
Oh, excellent. Thank you. Have a good evening.
Mayor, before you close, 2 things if I could. First, Bernadette understated the amount of time she has spent with Stacy and I over the last 2 weeks. She's still here is very impressive. The second thing, I shot an email out to you all pretty late today regarding we want to see if we can't get a little picture here. Maybe you can help me instead of me have to tap dance through trying to explain this. Would you mind, Shannon?
So this is the second year of City Hall Selfie Day, which will be on August the 15th, and it's GMA in partnership with a larger national organization, which is ELGL, which is engaging local government leaders. And so obviously having a brand new city hall, I would love for Milton to win in one of the categories. And so I'm trying to collect selfies now, whether there's a famous category, there's a best dress. So there are actually some of us who are going to don gowns and take a picture out in front of City Hall. But I'd love to get, Steve is not one of those. But I'd love to get one of council right now, if you're open to that, and then we'll save it and we'll post it as part of City Hall Selfie Day on August the 15th. And GMA is obviously encouraging participation. They would love to have a Georgia City win this year.
Okay, what do we need to do?
Just get together.
We need to scoot closer together.
If you all kind of stay together, you can stand up. And if you'll try,
Oh, do we have to actually do it?
And you have the selfie stick.
There's a little button right here.
And everybody kind of get in.
I think that's pretty legal in most places.
All right, can you guys see us get everybody in here?
Bill and Karen and Matt
And everybody smile. Take a couple if you would.
Get up so you can get the seal better.
Yeah, there we
Oops,
go.
got it. Get all your faces
All right,
together.
is everybody in here?
I think so.
1, 2, 3. Let me take one more just to make sure. 1, 2, 3.
Then you have to look at it for a little while, and then you do thumbs up.
And then while I'm here, I would like, on the 15th, we had talked about maybe doing, I don't think there's been one where the community's been engaged. So during the council meeting that Monday, if we can work to get on the agenda, it would be great to engage our citizens and get a group selfie as well. So thank you.
Thank you, Shannon. Okay. Anything else, staff, council? That'll conclude our meeting. Do I have a motion to adjourn?
Motion to adjourn.
Second motion. All right, I have a motion and a second to adjourn. All in favor, please say aye.
Aye.
Any opposed? That's unanimous.